I am interested though in one section of that dissent got into an issue that I've seen that I've been wondering about from Bruen, and especially from the dissent, the concurrence from Justice Roberts and Kavanugh, that effectively defended shall issue gun carry permitting, because as the dissent in this case points out, Bruen puts gun carry on the same plane of protection as gun ownership. At the same time, you have there's a footnote in the majority opinion, and then there's the concurrence, which I think is more relevant. At least sort of for tea leaf reading of where the court might go. But regardless, that the concurrence talks about how shall issue permitting could potentially be all right under the Bruen test for gun carry. And so that kind of implies that perhaps it's okay as well for gun purchasing. And so, what do you think of that argument? What was your response to it? How do you see that, playing out as you pursue this case further?
So I think you're talking about footnote 9, majority opinion, and that is what the concurrence talked about.
Yeah,
Justice Kavanugh and the Chief Justice, and that was in the context of vast majority of states, I think 42, actually had shall issue permitting systems for public carry,
right. And
that was very.
They do now, yeah.
Well, then they did, and now of course.
I just mean they didn't at the founding era. Obviously, there was no gun carry permitting.
At the founding era, but the court does this from time to time. I've been litigating in the Supreme Court a very long time, and sometimes they simply say, "Well, these are the parameters of our opinions, and this is what we're going to say in footnote 9 about the parameters of opinions." And I think what the court felt, and this is my supposition, is that this has been adjudicated by the states in such a way over time that there's a broad consensus with 42 states that this is something that can be reasonably required for carrying in public. None of those states, by the way, had this sort of arduous permit to acquire system. Not one. Maryland, at the time this case was adjudicated, was the only one. And of course, Maryland may issue. So you can't point to any of the 42 states and say, well, they applied the same sort of licensing requirement to the acquisition of a handgun or a long gun or any other type of weapon. So there is that distinction right there. And I think that the majority picked up on that distinction because as Heller said, the right to defend yourself in your home, which is acquisition would permit, is most acute. And because that's at the heart of the castle doctrine, like common law, where your home is your castle and you don't have a duty to retreat from it, and where an intruder is knocking at your door or busting through your windows. So there are different considerations in terms of defense of oneself in the home and of the home, and then defense of oneself outside the home in public, where public safety considerations are more important. And that distinction was recognized in all 42 of those states because none of them required that. So that's a principal distinction that the majority drew upon in this case, the HQL case. And I think it makes a lot of sense too. So you throw that into the fact that 42 states had drawn that distinction, and I think the court was willing to accept that. You can say, well, there's no history on that. And they probably felt it had been adjudicated to be reasonable and consistent with the Second Amendment in all these states. So they were willing to accept that without going into where the history of that is.
That's an interesting argument. Yeah, I haven't heard it put that way before. And, the court certainly does, especially in Bruen, focus quite a lot on what the consensus sort of is.
There is. And this is not
supposed
just
to go back to the consensus at the founding, but I do think that they often try to avoid, it does seem to me like the court wants to avoid striking down laws that are either extremely broadly popular or, have been around for a very, very long time. That seems to be they're conservative and especially in that particular sense.
The court is always
at
sensitive
least when it
to
comes
the
to gun
practical
laws.
implications of its rulings, but
Yeah.
this concept of adjudication is well recognized and has been applied in other circumstances in Supreme Court decisions as well. So that's nothing novel to it. So
Okay. Well, we'll have to see what they actually do if that question gets presented up at the court.
I'm confident at some point it will be, because this issue is being raised all over the country.